Good afternoon, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have a lot going on this afternoon, and I'm going to read for you the newest thing to hit the docket, which is the New York Times motion to dismiss Justin Baldoni's lawsuit. I was actually coming on to do an update about Blake hiring that crisis PR firm, as well as the statements the lawyers made when they were kind of trading back and forth in the press today about the subpoenas. However, then I saw this had just popped up on Pacer, so we're going to go through that first. I'm going to wait just a minute for some other people to filter in here if they want, because I feel like this is a pretty big update, so I don't want to start too early. Just give me 1 sec, okay? Hi, Lady Jen. How's it going? Make sure I got this here. Yep. I'll go ahead and pull up the screen just while we're getting ready for that. Ashley, hi. How's it going? Okay. There we go. So we got one smaller document we got to read first, which is just 3 pages, and it's like a nothing burger, really. But I do like to show everything that comes up, so I will do that. It's pretty much just this paragraph, but let's give it, like I said, just 1 more minute to see if anybody else wants to pop in here and join us. You changed your name. I thought you were maybe the same Jen, but I wasn't sure. Hey, Liam K. Hey, Bodie. What's up? How's it going, everybody? Thanks for joining me. I appreciate it. All right. Just refresh this page real quick. I'm going to save these for later. I'll put out a pre-recorded video about the crisis PR firm and the statements back and forth after this live stream, because we just want to get into that. But while we're waiting for people to come in, why don't I just read for you really quickly what Blake's lawyer had to say about the subpoenas and what Brian Friedman, had to say about the subpoenas. 1 second here. I just had this. Okay, so Blake's attorney had said, or not attorney, but one of her representatives or a spokesperson for Blake had put out a statement today stating, "What is Brian Friedman hiding?" After promising to release all the receipts, Friedman ran into court to keep secret the phone records of who Baldoni, Heath, Sarowitz, Nathan, Wallace, and Abel were calling during their retaliatory campaign. So instead of getting these records from the phone carriers the way we initially requested, the judge has ruled that if we simply submit more specific requests, we will be able to get the records we're seeking. Today, we will do that. We are submitting those requests directly to defendants involved, and we look forward to seeing the records. On the flip side, Baldoni's main lawyer, Friedman, saw Judge Lyman's ruling as a hard loss for Lively. The court put a stop to Ms. Lively's egregious attempt to invade our client's privacy. This is a big win. No matter how the Lively parties may try to spin this decision, the court saw their efforts for what they really are, a desperate fishing expedition intended to salvage their debunked claims long after they already savaged our client's reputations in the New York Times. Speaking of the New York Times, let's go ahead and take a look at what they had to say in their filing. Now, this is the second motion to dismiss Justin Baldoni's complaint. As you know, the PR firm for Blake Lively had also moved to dismiss. Lynette Burgess, thank you, Lauren, for doing such an outstanding job. I'm 71 years old, living in England, and obsessed with this case. Well, thank you very much for joining me, Lynette, all the way from England. Wow. It's pretty cool to see everybody watching from different places in the world. Okay. Please take notice that upon the annexed memorandum of law, which is like the meat of this, which we'll get to in just a second, declaration of Catherine M. Bolger dated February 28th, and exhibits 1 to 9 annexed thereto, consolidated defendant, the New York Times Company, by and through its undersigned counsel, will move this court before the Honorable Louis L. Lyman at the United States Courthouse for the Southern District of New York for an order dismissing the First Amendment complaint of Consolidated Plaintiffs Wayfair Studios, LLC, Justin Baldoni, Jamie Heath, It Ends With Us Movie, Melissa Nathan, Jennifer Abel, and Steve Sarowitz with prejudice pursuant to Federal Rule of Civil Procedure 12b6. All right, now here's the more interesting stuff. We can go ahead and close out of that one. And guys, as always, I will post these to my Twitter page after we finish the stream and to my YouTube page under the Posts tab. All right. Hey, Palaver Girl. Right. So we have the background, the arguments. We're going to skip this part right here because we don't need that. And I'm sure my friend Omar, the Tilted Lawyer, is going to go over some of this stuff to give legal analysis later today. If you've seen any of my live streams reading these documents, you know who Omar is probably. He's really great, so you should definitely give him a follow and look out for his live stream tonight. Okay. Over the course of their 224-page first amended complaint, FIC, plus an added 168-page timeline, the Wayfarer parties breathlessly tell their side of an ongoing Hollywood drama involving actors Blake Lively, and Justin Baldoni. The stars of the film It Ends With Us. The FAC first amended complaint has, to some extent, achieved its obvious purpose to Wayfarer party's story, has been reported by countless news outlets during the last few weeks. What the complaint has not done, however, is plead a viable claim against the New York Times. I just want to point out here, they're saying the Wayfarer parties breathlessly tell their side of an ongoing Hollywood drama, and I feel like I am breathlessly telling both sides of the story of this Hollywood drama that's ongoing. So, you know. Anyways, doing my best here, guys. Doing my best. Okay. Plaintiff's claims arise from an article titled "We Can Bury Anyone Inside a Hollywood Smear Machine," published on December 21st, and a related video, both reported on a sexual harassment and workplace retaliation complaint Lively filed with the California Civil Rights Department against some of the plaintiffs. That complaint included text messages between Baldoni, his publicist Jennifer Abel, and Melissa Nathan, a so-called crisis PR specialist, who told Abel that "we can bury anyone." And then the CRD complaint. One sec, guys. Just gotta make sure I told my boss I'm on my break. Okay. Notwithstanding the sound and fury of the FAC, plaintiffs attempt to assert claims against the Time for defamation, false light, promissory fraud, and breach of implied in fact contract fail as a matter of law. The bulk of the Wayfarer party's FAC must be dismissed because it is an impermissible group pleading under Rule 8 of the Federal Rules of Civil Procedure. And that is also a claim that was made in the other motion to dismiss by the PR firm. So, okay. Thank you, mods, for being here, by the way. Okay. Yes, so down here in the footnote, they're just saying they're joining the motion as well. They're joining the motion made by the defendants, Vision PR and Leslie Sloan. So, looks like there might be one other new document on the docket, guys, and I don't want to miss anything, so why don't we check that out real quick. This will only take a second, I promise. Okay. And then we'll get back to reading that. These things just keep coming in back to back to back. So it's like I'll check so often. I'll check like once an hour on a day when I know something is due. And then, of course, everything comes in like right at the same time when I'm trying to do something else. There we go. Yeah, there is one more. Oh my God. There's two more documents. Holy. Oh, okay. So these two just came up. Give me one sec. Oh, that's 120 page. Oh, okay. Let's do this. I'm gonna get that one too. Oh God, it's $12. Of course it is. At least now you guys can see what I'm doing when I get these documents, because sometimes they're not on Court Listener right away. All right, so I'll download that. Pull that up. And this is a declaration of Catherine Bolger in support of motion. Okay. So we'll get to that after this document we're reading right now. I can't believe we're going to go through over 100 pages. Hang on. And then there's one more document here. And that one's only 1 page. So we will look at that last. So it's like, even when I have everything up, I don't, because there's going to be more. All right. There we go. Now let's move back to what we were reading. In addition, the defamation claim fails because the sole allegedly defamatory statement the Wayfarer parties managed to identify as actually having been published by the Times, that they orchestrated a smear campaign against Lively in retaliation for her complaining about sexual harassment, is unquestionably and absolutely privileged pursuant with New York civil rights law, Section 74. In any event, the defamation claim is insufficient as a matter of law because the challenge statement is protected opinion. I don't know if that's a protect. Okay. And because the Wayfarer parties plead nothing but conclusory allegations regarding the Times' purported actual malice. Right. 1 second, because I'm just moving these documents next to each other so I can stay organized. Because otherwise this will get real confusing real fast. There and got that there. Okay. Again, thanks everybody for your patience. I appreciate it. I really do. Okay. Okay. Plaintiff's remaining claims fare no better. The false light claim fails because New York law applies to this action, and New York does not recognize the tort of false light. And the tag-along promissory fraud and breach of implied in fact contract claims fail because the documents incorporated by reference into the FAC demonstrate, among other things, that to the extent that the Times made any promise to plaintiffs, that promise was kept. And remember, there's some argument about the timeline the Times was giving them to respond and when they actually went ahead. So I guess the Times is going to give us their side of that, and we'll see who seems more believable, shall we? All right. Okay. Got it. Sorry, guys. Like I said, I had to take a break from work, so I had to text my boss. Okay. While the Wayfarer parties will doubtlessly continue their efforts to litigate this case against Lively in the court of public opinion and the court of random opinion, their claims against the Times have no place in this court of law. The complaint should be dismissed. Background. A, the parties. We have Baldoni is a Los Angeles-based actor. Steve Sarowitz is the co-chairman of Wayfarer. They're just laying out who everybody is, so we're going to skim over that. The article. Okay. On December 21st, the Times published the article. See Declaration of Cashler and M. Bulger, which is the 127-page document that we're going to get to right after this. Explicitly relying on and citing to the CRD complaint and the text messages, emails, and other documents included therein, the article reports on Lively's allegations of misconduct by Baldoni and Heath, Baldoni's subsequent engagement of Nathan, and Nathan's attempts to tarnish Lively's reputation at Baldoni's behest. The article is accompanied by the video, which features one of the article's writers, Megan Twohy, summarizing the article and noting it was based directly on the CRD complaint. Prior to publication on Friday, December 20th, Ms. Twohy, a Pulitzer Prize-winning journalist, congratulations, I'm not sure what that has to do with anything, but okay, engaged in routine news-gathering practices by contacting Baldoni and the other subjects of her reporting to seek comment on the allegations made in the CRD complaint. Ms. Twohy's emails included an extensive list of the allegations cited in the article, sought comment on them, and asked each person to notify her of any inaccuracies or other information they thought the Times should know. Okay, and it'll show that in the declaration. The emails also invited each party to talk to the Times on the record. They concluded that a response was needed by 12 p.m. Eastern Time the next day. The emails made no representations whatsoever about when the Times would publish the article. Approximately 2 hours later, Abel sent Ms. Twohy a 307-word denial of all allegations attributed to Brian Friedman, counsel for the Wayfarer parties. Ms. Twohy followed up to clarify that the response was on behalf of Abel, Nathan, Heath, Sarowitz, in addition to Baldoni and Wayfarer, which Abel confirmed. Let me just make sure we didn't miss anything here. Yeah, that's the article they cited. Communications between the Times on the one hand and the Wayfarer parties on the other are incorporated by reference. Okay. No representative of the Wayfarer parties reached out to the Times after Abel's last email at 11:54 p.m. The article was published at 10:11 a.m. on December 21st, 2025, quoting extensively from the Wayfarer party's response and linking to the full response. The video also includes the Wayfarer party's denial. On December 31st, the Wayfarer parties filed suit against the Times in California State Court for defamation and false light invasion of privacy arising out of the publication of the article. That complaint was well publicized. Counsel for the Wayfarer parties gave several interviews about its contents, but it was never served. And we talked about that yesterday, guys. When we went over that court transcript, which, by the way, we went over that in a stream. So if you want to see that court transcript and what they talked about there, you can. Oh my fuck! I just got another notification for this docket. Hang on, guys. They're trying to kill me right now. I swear. God, if only Bruce were here to help. Okay. Just bear with me 1 minute. I want to make sure we get everything there is to know. So I don't want to miss anything for you guys. Or have to do another stream. You know? So. Okay, the judge has just ruled on the... No. That's Bolger's wrote a letter to the judge about the discovery. So we'll get to that after. There's a lot coming up. So, like, you're going to see me in real time just be like, what the fuck is this? Sorry. It's a little stressful. Not going to lie. A little stressful. Okay. On December 31st, Lively filed suit against the Wayfarer parties in court. The Wayfarer parties countersued on January 16th. 2 weeks later, on January 31st, the Wayfarer parties amended their complaint in this court to name the Times as a defendant, ultimately dismissing the previously filed California lawsuit. In the First Amendment complaint, the Wayfarer parties assert claims for defamation and false light invasion of privacy against the Times, as well as claims for promissory fraud and breach of implied in fact contract. The Times was served on February 7th, and this motion follows. Okay, now we're into the argument. Whoa. Whoa. Throughout their blunderbuss complaint. Took you 21 days to come up with that. The Wayfarer parties seek to drag the Times into their larger feud with Lively. But the only thing the Times is, in fact, alleged to have done is engage in news gathering and publishing an article and video about the Wayfarer/Lively dispute. I don't like the way we're framing that, but all right. The Wayfarer parties have failed to allege a claim against the Times, and this court should, therefore, dismiss the FAC as alleged against it pursuant to Rule 12b-6. To survive a 12b-6 motion to dismiss, a complaint must state a claim to relief that is plausible on its face. That standard is met when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The plaintiff must show more than a sheer possibility that a defendant has acted unlawfully and may not rely on threadbare recitals of the elements of a cause of action supported by mere conclusory statements. In addition, courts in the Southern District have recognized that because a defamation suit may be as chilling to the exercise of First Amendment freedoms as fear of the outcome of the lawsuit itself, courts should, where possible, resolve defamation actions at the pleading stage. Okay, and then A, it says New York law applies to Wayfarer parties' claims. New York law applies to the Wayfarer parties' claims against the Times. While the Times believes the outcome of this motion would be the same under either jurisdiction's law, so California or New York, because like we said earlier, they did file it initially in California. They decided to drop that and then add them as a defendant in that amended complaint, because they initially hadn't added the Times to their lawsuit in New York with the original complaint. So they're just explaining here why the New York law applies rather than the California law. And so we're going to skip over that, and you guys can listen to, some of the law tubers go over the legal analysis of all that and why that matters. But I just want to get to the meat of it. Stuff that a normal person who doesn't quote case law would care to read. All right. Let's see. Their justified expectation that their conduct will be judged by the rules of jurisdictions in which they carry on their activities merits protection. Okay, they're citing some case law there. So they're just justifying that New York law applies here. This case had even stronger connections to New York than Jacob did. Okay. The Wayfarer parties allege that the Times is a New York corporation with its principal place of business in New York, where Lively and Reynolds allegedly also reside. I don't think that's alleged, is it? It's a fact. Don't they have a home there? The Wayfarer parties allege that Lively and the Times worked hand in glove. Hold on, it's my sister. Hello?
I'm on the way with Bunny.
Oh, shit. Okay. Thanks. Bye. Sorry, guys. Wayfarer parties allege that the article is based on information provided in New York by individuals residing in New York to reporters in New York. And there's no question that article emanated from New York as well, or that the Times' principal place of business is in New York. Moreover, the Wayfarer parties... One sec, guys. Moreover, the Wayfarer parties, like the plaintiffs in Jacob and Kinsey, acknowledge New York's interest in this case by choosing to drop the California state court action and bring their lawsuit in the district. Okay. Impermissible group pleading. Like I said, we saw that one in the publicist's motion to dismiss. Sorry, I'm asking Bruce if he can jump in here and help me for a couple of minutes. Sorry about that, guys. Obviously, I don't want to keep stopping and starting again, but obviously, if he doesn't help, then I have to run downstairs and get my dog from my sister. But I will. I will make it fast. I promise. Okay. First, the plaintiff's complaint fails to satisfy the requirements of Rule 8 to the Federal Rules of Civil Procedure because it is made up almost entirely of impermissible group pleading that lumps all the defendants together in each claim and provides no factual basis to distinguish their conduct. In fact, this court need look no further than the very first paragraph of the amended complaint to reach this conclusion. There, the Wayfarer parties define the Lively parties to include the Times, and then for the next 224 pages, allege that all Lively parties were acting in concert together, including committing acts that predate the publication of the article. Well, can you prove that you did not have anything to do with that before it was published? I mean, it sounded to me like they were given a lot of information ahead of time, but this form of pleading is clearly impermissible under Rule 8. Okay. All right. So I'm skimming over some of the case law stuff, guys. Oh, there's Bruce. Hey. How's it going?
Ladies and gentlemen. Oh, boy. What is happening?
Well, oh my God, so much stuff is coming out right now, and so I'm trying to read through this, but I have to get my dog from my sister in a minute, and so I might need your help just for a few minutes.
Sure.
And then I'll have to text my boss again in a little bit, but yeah, you don't have to stay the whole time if you don't want to, but I appreciate obviously you jumping in. Hey, Sarah. She says our favorites are here.
Ooh.
All right. So I'm reading this motion to dismiss by the New York Times. They say, and this is about the impermissible group pleading. Yeah. All right. In this way, the Wayfarer party's FAC is like that in Komatsu, which the court dismissed in part because the complaint's length and tangents make it difficult to understand exactly how the facts alleged provide a basis for plaintiff claims, or which facts support which allegations, causing significant prejudice to defendants who must sift through hundreds of pages to fully ascertain the nature of the charges against them. Well, it's no cakewalk for me to sift through either, I'll tell you that. Here, as there, the Times must parse the Wayfarer party's extensive verbiage, much of which does not relate to the Times at all. Oh, please, you're eating that up. You want those views. Don't tell me that. Don't even tell me you care about that. All right. This vague, convoluted pleading, which fails to properly allege what the Times actually said, whether it was false, and whether it was published with actual malice, is impermissible under Rule 8. It is all the more unacceptable because plaintiffs have already amended their allegations against the Times and therefore had the opportunity to fix their pleading problem. For this reason, dismissal with prejudice is appropriate. And then here they're saying the Wayfarer party's defamation claim fails. The only exception to their scattershot, they keep using these words, scattershot pleading. It's like, I don't know, they just keep throwing in little pot shots everywhere.
Yeah, whenever I see all these sort of creative adjectives, it's like a red flag, right? Like, Because
I
you
don't
should
know,
be
man.
able to make your arguments without them, or at least without a lot of them.
Yeah. I don't know, man. I mean, it makes it more interesting for me to read for sure, but it's not nice, guys. It's not nice. Hang on. Text one here. Okay. Let's see. Scattershot pleading comes at page 166, where they seem finally to land on the claim that the Times defamed them in the video, which stated the men, Baldoni and Heath, hired a crisis PR manager, Nathan, who orchestrated a smear campaign against Lively. That is the only allegedly defamatory statement made by the Times that is identified. Well, one is still defamation, yes? That identified in the FIC, and it is therefore the only statement at issue in their defamation action. The Wayfarer party's claim based on this one statement, however, must be dismissed. Sorry. My sister's being difficult. Give me 1 sec. My iPhone's being difficult. All right. The fair report privilege applies to the Times' publications. The claim must first be dismissed because the statement is absolutely privileged by the New York Fair Report privilege. New York's fair report privilege protects any fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding. There are two requirements for the privilege to apply. First, the report must give a substantially accurate account of a judicial or other official document. Second, the report must attribute its allegations to that document. When those two conditions are met, the report's publisher cannot be held liable as a matter of law. We have a footnote relating to the defamation. Let me make sure we didn't miss anything significant there. There's Church of Scientology. What? Okay.
Oh,
The
boy.
defamation claim also fails as to It Ends With Us movie and Sarowitz for the additional reason that the Wayfarer parties fail to allege, as they must, that the allegedly defamatory statements in the article or the video are of and concerning them. And then they cite Church of Scientology International versus Time Warner Incorporated. Let's see. The article does not discuss It Ends With Us movie at all. It mentions Sarowitz as a defendant in Lively's suit and as the financial backer of Wayfarer. Okay, but Wayfarer, who you alleged, launched a smear campaign against Blake Lively, which is the alleged defamation, I believe. So, let's see. The Times does not report that he had any role in Baldoni's purported retaliation against Lively or in Nathan Abel's actions. I don't know. I don't know about that one. I'll have to go back and look at the actual words they used, Okay. The privilege was established to implement the public policy in favor of encouraging publication and dissemination of judicial decisions and proceedings as being in the public interest. It exists to protect the media while they gather the information needed for the public to exercise effective oversight of the government, even when they report on official action that the government would like to keep secret. Gubarev versus BuzzFeed. We're getting lots of weird case stuff cited in here. Names I haven't seen in a while, like BuzzFeed and Scientology. I thought both those things were dying off, but I guess not. Here there's
Welcome to California.
Yeah, right. Rainbow Pickle says, I'm sure you'll go crazy over Blake, CIA, Nick Shapiro. Yeah, so I did mention in the beginning, I was actually coming to stream about how she hired Nick Shapiro for crisis PR, but then this all came out. So, okay. The article and video meet both requirements of the fair report privilege.
Okay, let's see.
First, even as plaintiffs seem to concede, the CRD complaint is precisely the type of official proceeding at the heart of the fair report privilege. New York courts have broadly construed the meaning of an official proceeding. Okay. I'm skipping over the case stuff. And it indisputably applies to legal filings, including complaints. Okay. Actions and documents involving administrative agencies are official proceedings protected by the fair report privilege.
Okay, so was this article published before or after the original complaint?
So gosh, I can't remember now. If it was I think it was a little bit after she did the CRD complaint, or maybe a little bit before. It was around the same time, I thought.
It could matter.
So, well, yeah, definitely. But I just can't remember. Yeah. Someone in the chat, please tell us. So
I was thinking a timeline would be very important for this case.
Well, we have another document. Well, we'll probably have that. So we just have to get through the rest of these pages first. which are filled with case law stuff that I'm going to skim over because Omar's going to have to do that part. And so too are documents related to non-public official proceedings. Okay. This case says, stating that New York's privilege serves the public interest in the dissemination of information by providing broad protection to news accounts of official proceedings, including not only judicial and legislative proceedings, but also classified proceedings, internal quotation marks and citation omitted. Okay. Here, the allegedly defamatory statement in the article reports on allegations that were included in a filing before the CCRD. The CRD is the administrative agency responsible for receiving, investigating, and prosecuting complaints alleging unlawful practices in the workplace, and from whom a filer must obtain a right to sue notice in order to initiate her own lawsuit. And we saw that right to sue notice in the lawsuit that Jed Wallace filed against Blake Lively in Texas, because he attached that as an exhibit. Reporting on a complaint. Okay. Hang on, my sister's like at the door. Are you able to see that well enough? Bruce? You're muted.
I'm muted. Yeah,
Yeah,
I
dude.
can.
Okay, hang on.
Yeah,
So we got to hear stating the right to sue letters provided. Reporting on a complaint filed with such an administrative agency falls squarely within the bounds of the privilege. In fact, a court in this district recently found that a complaint filed in similar California agency proceeding was an official proceeding for the purpose of Section 74. So this is indeed the Wayfarer parties effectively concede that the privilege applies to a complaint filed with CRD in the amended complaint. Could I get you to read here from next to the bottom of the page? I'll be right back.
Sure. All right, guys. So we've got next, the article and the video attribute the allegedly defamatory material to the official proceeding. For the privilege to apply, quote, the ordinary viewer or reader must be able to determine from the publication itself that the publication is reporting on a proceeding, unquote. Okay. And then they have a citation for that, which says privilege applied in part because the Times, quote, notes that it is reporting on a specific court proceeding and that 7 declarations were filed in that proceeding, end quote. Quotations from and summaries of documents or other material that the report indicates are part of a proceeding are indisputably statements of that proceeding. Okay. And then they have another citation. They say comments that essentially summarize or restate the allegations of a pleading filed in an action are the type of statements that fall within Section 74's privilege. So they're basically saying, hey, there was this filing, and we're just reporting on what's in the filing. We're not making those claims ourselves. We're just reporting that's what's in the filing. Okay. It seems to be their argument. There is no real dispute that the article reports on the CRD complaint. The article consistently uses language like, quote, according to a legal complaint, unquote, and according to a legal complaint. Well, they were supposed to cite the source too. That was the second part of it. We'll see if they get there. And, quote, the CRD complaint claims, unquote, to describe Lively's allegations about the Wayfarer parties. Compare, for example, article at 2 with Bolger Declaration Exhibit 3, the CRD complaint. And the article quotes extensively from texts and emails between Baldoni, Heath, Nathan, and Abel that are reproduced in CRD complaint. Compare, for example, article at 7, quoting Abel stating, quote, I think you guys need to be tough and show the strength of what you guys can do in these scenarios. He, Baldoni, wants to feel like she can be buried, unquote. With CRD complaint, paragraph 13, same. Plaintiff concedes as much. See the FAC, paragraph 262. Okay. And then there's a footnote here. What's in the footnote? There's another case citation, looking at privilege. Okay, whether the average reader of the media report would understand the statements as communications about the complaint. Okay. So they're basically saying, hey, we are reporting on these communications because they were in the original complaint. And that's all we're doing here. So we've done nothing wrong. We'll see if their argument holds any water. Oh, we've got a pupper. Breaking news.
I just had to get him from downstairs real quick. Sorry, guys. Hey, baby. You go. All right.
So, from my I've been here 5 minutes.
Yeah.
It seems like what they're arguing is they're sort of saying hey, our article was jank, but it was okay because it was just a copy of the original complaint, which itself was probably just jank.
Right. I mean, it kind of does kind of sound like that.
Yeah.
It'd be like, I don't know, if you wrote a scathing diary entry, or rather I would, let's be realistic. If I wrote a scathing diary entry about someone and then you published it in your newspaper and wrote all those awful things that I said in my burn book.
Oh, yeah.
And then you were like, well, all I did was say what was said, except I would have had to
you'd
submit
you'd have to file it as a
right. That's what I was about to say.
As an official complaint.
I'd have to file it as to the principal as an official. I found this in the girls' bathroom or whatever it was that happened to Regina George.
And then you could leak that filing to me, and I would publish it in my Moose newspaper. And
precisely. Yeah.
Oh my.
That's basically exactly the same thing. Yeah. Right. That's the same.
Sure.
Right. Were you at the bottom of the page here?
Yes.
All right.
In fact,
not only do the article and video reference the CRD complaint multiple times, but the article links to a full copy of the filing. No ordinary viewer or reader could fail to understand that the article and video reported on the CRD complaint. That the article reported what? On the CRD Oh, I see. Okay. That it reported on the CRD complaint. No ordinary viewer or reader could fail to understand that it reported on the CRD complaint. I want to raise you a bunch of fucking morons, because that's just not true. I'm sorry, but that's just not true. Lots of people could fail to understand that. So a lot of people probably don't even know what a CRD complaint is. Not gonna lie to you, I'd never heard of one before.
Well, I think their argument here is that they included some kind of link to it, to a full copy of the filing. And they're saying, well, if you...
I maintain that people are, in fact, stupid enough to not understand that. And they're saying, no ordinary viewer or reader. And I disagree.
Mm-hmm.
But, I'm not the judge. So, all right. Somebody says they also had December 31st date as of 2025 in the first mention. New York Times literally living this case in the future. Oh.
Oh, my.
Okay. Well, that's uncomfortable.
Somebody wrote the wrong year?
Maybe.
Sounds familiar.
Okay. Yeah, it does. Oh, God. Okay. Finally, the article and video fairly reported on the CRD complaint. In keeping with the policy of giving Section 74 a liberal interpretation, courts deem a report fair and true so long as the substance of the article is substantially accurate of the official proceeding. Okay. And they're citing another case here. When determining whether an article constitute a fair and true report, the language used therein should not be dissected and analyzed with a lexicographer's precision. What's a lexicographer? Is that like a wordsmith or something?
I don't know. We can look it up.
I kind of felt like if anyone knew, it would be you.
Where is it on this page? I'm missing
right here, lexicographer.
Oh.
Mm-hmm.
Oh boy, the language should not be dissected and analyzed with a lexicographer's precision. Oh, that does sound like me. Okay.
Yeah,
you
dude.
Keep reading.
Right?
I'm going to look this up.
All right, we'll do.
I'm going to put this on my LinkedIn now.
Oh God. This is so because a newspaper article is, by its very nature, a condensed report of events which must, of necessity, reflect to some degree the subjective viewpoint of its author. Okay. Here, it cannot be disputed that the article and video accurately summarize the CRD complaint in regard to the sole defamatory statement alleged by plaintiffs, that they engaged in a smear campaign. The article and video summarize the filings allegation that Baldoni engaged Nathan and able to tarnish Lively's reputation in retaliation for complaining about Baldoni and Heath's purported misconduct. And then, again, they're citing stuff we're going to see in the next document, so it sounds like they're going to lay out a lot of stuff there. The term smear campaign, though not used in the CRD complaint, is a fair and accurate shorthand way to summarize the main thrust of the allegations, supporting the allegations of retaliation. Okay. And then they're citing the CRD complaint there where it says, alleging that Mr. Baldoni and his Wayfair associates embarked on a sophisticated press and digital plan in retaliation for Miss Lively, exercising her legally protected right to speak up about their misconduct on the set.
Something about the allegations supporting the allegations.
Yeah, pretty much.
I don't know if that's a typo or if that's what they literally mean, that we're at this inception level of House of Cards allegations at this point. I don't.
Well, yeah, I guess because we're not lawyers, so we're both just kind of like, all right.
It's amazing.
Yeah. Okay. Let's see. We got through that. The article and video even provided a fair and accurate summary of the allegations from Lively that the plaintiffs do not identify as defamatory. Lively's allegations of sexual harassment made in the filing, including claims that Baldoni engaged in unwanted improvised kissing of Lively while on set, and Heath watched Lively breastfeed her child even after being asked to stop. Okay, well, we've seen a lot of counter claims to that, but we'll just keep going. The Wayfair party's arguments to the contrary are wrong. In a half-hearted attempt to defeat the privilege, plaintiffs gesture at 3 arguments to claim that the article is unprivileged. All fail. Okay. First, the Wayfair parties contend that the Times colluding with Lively was given her CRD complaint prior to filing. Even were that so, receiving an advance copy of an official document before filing does not vitiate? Vitiate? I don't know what that is either. The privilege. Oh, wow. So here in the footnote, it says, tellingly, the Times was not the first news outlet to report on the CRD complaint. See, Blake Lively sues Justin Baldoni for sexual harassment, claims of wild behavior on set, TMZ. Okay. As this court has held, even if a journalist is passed a copy of the complaint by the filing party, that would not prevent the journalist from reporting on the complaint or deprive her fair and accurate report of the benefit of the absolute privilege accorded it by New York law. The Wayfair parties claim that the Times interviewed Lively before the publication of the article and video similarly does not change the outcome. Right. Again, we're skimming over the case law stuff. Second, the Wayfair parties hint that they believe the article and video are not privileged because the Times made little or no attempt to investigate the veracity of Lively's allegations. That is not so, but the argument exhibits a fundamental misunderstanding of the privilege and its purpose. The point of the privilege is that journalists should be free to accurately inform the public about official proceedings without having to fact-check them.
You know, this makes me want to go back and read that original Times article now.
Yeah, I mean, I guess I'll have to go back and do it too. I went over it a long time ago, and then we have another footnote here about internet sleuths. It says, as perhaps could be predicted, because the Wayfair party's allegations rely solely on internet sleuths, the allegations regarding the metadata associated with the article and video are simply wrong. And I guess they'll explain that in the next document we go over. Okay. Well, it was on Reddit, so it can't be wrong. Everything on Reddit is true.
Oh no.
Yeah, there's no creative writing on Reddit. The point of the privilege is that journalists should be free to accurately inform the public about official proceedings without having to fact check them. Okay.
Right. So it really gets to the heart of what were they saying in their article? Were they presenting the things in their article as facts, or were they presenting them as here's what's in a filing, and we'll have to see if it's
somebody
true or
said
not.
Somebody says they said they did fact check them. So that would be a problem, yes, if they did say that they fact checked them, because then it is like presenting it as this is a verified fact.
Yeah, and is it like the telephone game where when they say fact check, they just mean, hey, we made sure that these statements were in the complaint and that we reported on them with the correct syntax as opposed to the substance of the claims? It's very interesting.
Virtual Tourist says, okay, but what official proceeding had occurred at the time of this article? I think they're referring to the filing of the CCRD complaint and then the resulting right to sue letter that Lively obtained. So I guess you could count that as a proceeding, right? Because the article is indisputably correct, because the article indisputably correctly reports the contents of the CRD complaint, the article is privileged. So as long as they didn't misrepresent anything there,
Yeah, so if these text messages are being taken out of context in the complaint and then the article presents them as such, it's interesting because presumably they had all the other text messages as well.
Yeah. Well,
Which
that's
is what
right.
this commenter is saying, right? They went through thousands
Right.
of texts and verified them.
Right.
Oh boy.
Okay. So that would mean they were saying, like, as a factual matter, like, what she's saying happened is true. We saw the texts, and they're not saying this is up for interpretation. They're saying this is what happened. Yes.
Yeah, I mean, it's one thing to go out and write an article and say, hey, there was a filing. Here's exactly what's in the filing. Done. And probably that's what TMZ did, I would imagine. Right. I feel like the argument here is that the Times did something above and beyond that, which is like, hey, we also got access to all this stuff that other people don't have. And they've sort of presented these optics that they had done more investigative journalism than, say, a quick TMZ article.
Right. Yeah. Okay. Huh. Let's see. Sorry, I was just checking a tab right there. Nonetheless, the Times went above and beyond this requirement and did reach out to plaintiffs. The article not only includes the Wayfarer party's strident denials, but also links to their statement in full. See article at 2. So I think that's on the next one. The Wayfarer parties may have wanted the article to tell a different story, but that desire does not transmute absolutely privileged reporting into actionable defamation. Despite the Wayfarer party's hundreds of pages of screen grabs, outrage, and rhetoric, this is a very simple case. The article is absolutely privileged as a fair report, and the Wayfarer party's defamation claim fails. All right. I don't know. I'm curious to see what other people in the chat think about this. Like, is this a good argument? Because to me, like, I've never seen one of these cases before, and I'm kind of like, this is a little bit interesting to me. It makes me think a little bit, at least. You know, we've obviously seen some filings from other lawyers, Bruce, you and I, that don't really make sense, and so we're obviously like right away like, no, that's not it, that's not it, that's not it. But here I'm kind of like, okay, this may be a little bit more complicated than I thought.
Yeah, we'll need the law sphere to weigh in on whether this is a good argument or not. I will say that in being able to pick it up in a few minutes, it's at least reasonably well written.
Yeah. I mean, comparatively, I mean, we started out. I started out at
whether
least
it will work.
Yeah, my foray kind of into the legal world was littered with absolute bullshit writing. So it's like, this is an improvement. So it's like anything would be an improvement. So it's kind of hard to say. Yeah. All right, let's see. The smear campaign phrase is protected opinion. Even if the fair report privilege did not apply, plaintiff's defamation claim would still be subject to dismissal because the challenge phrase is constitutionally protected statement of opinion. Smear campaign is no more than rhetorical hyperbole that lacks any precise meaning. All right. And whereas here, such a colorfully expressed judgment is based on disclosed facts, that judgment is not actionable.
Does anything mean anything? Oh.
Here, the article lays out in great detail the factual basis for its conclusion that plaintiffs engaged in a smear campaign against Lively. Butter, stop licking my foot. Please stop licking my foot. All right, I should have worn tennis shoes.
Okay, so
the article cites texts and documents establishing that, for instance, Baldoni wanted a plan to combat steps taken by Lively, that he was unhappy with the initial proposal provided by Nathan and Abel, that Baldoni wanted to feel like she can be buried, and that Nathan acknowledged that we can bury anyone and did not want to send Baldoni the work we will or could do because that could get us in a lot of trouble. Dude, I don't know. Like I said, I feel like a lot of these things are taken out of context, and I feel like they've been presented in other filings in a much different way where you could see the full context. And so this doesn't really ring true to me. But again, I'll have to like go back and like look over some of this other stuff so I can really kind of sit down when I have more time and be like, okay, this is what this says, but this is why this doesn't make sense, or this is why this does make sense. Which I will do, but right now I'm just trying to kind of share this with everybody. So.
I think the problem I'm picking up here is they're saying like, hey, we didn't do anything wrong because we reported on what people said, but they didn't report on everything everybody said.
Right.
So it's sort of a sin by omission. And is a sin by omission, does that rise to the level of defamation?
Yeah.
So I think at least from the public perspective, maybe not from the lawyer's perspective, that's maybe the question here.
Yeah. Let me see one sec. Where were we here? That Abel considered planting pieces of how horrible Lively is to work with, And again, I didn't see anything like that, but that Nathan had talked to journalists receptive to such stories. And I remember there were screenshots of her talking to a journalist, and the journalist had contacted both her and Lively's publicist. And that's, again, not how I felt like that went. But I will, again, look back at it and see. That Baldoni proposed flipping the narrative on Lively and Reynolds by using their own words against them. That Nathan, is that really a smear campaign, though? If you just, hey, this is a fact. This person said this. I don't know. That Nathan and Abel retained an individual named Jed Wallace to boost and amplify online content that was favorable to Mr. Baldoni or critical of Ms. Lively. That Nathan was told that her team was starting to see a shift on social due largely to Jed and his team's effort to shift the narrative towards shining a spotlight on Blake and Ryan, and that negative social impressions of Lively subsequently increased. So when I was looking at this shining a spotlight on Blake and Ryan at that time, I really thought that, because there was a lot in the press that was people were speculating about drama between the cast and stuff like that. So I read that and I thought maybe they're trying to get some more positive press for the movie, because he's not doing any of the press with the other cast, and people are just like, what the fuck is going on here? And so maybe they just wanted something, that was a little bit more, or a little less negative for the movie, rather. I don't know, because it didn't seem like they wanted this to come out at all, this conflict at all, Justin's side of it. So I don't know. That was just me. Okay. And that Nathan bragged to Abel that all press is overwhelming. We've confused people. So much mixed messaging. The purportedly omitted context flagged in plaintiff's... the complaint merely establishes that Nathan had a reputation for being able to plant negative stories. It does not undercut these facts, which support the conclusion that the Wayfarer parties planned for and executed a smear campaign against Lively. So they're just laying that right out there. This is exactly what happened. We're not even beating around the bush anymore. That's what happened. That's a fact. And they're saying that in a legal filing, not an article. So it's a little different. The smear campaign phrase is constitutionally protected opinion based on disclosed facts, and the Wayfarer party's defamation claim fails for this independent reason. Number 3, the Wayfarer parties have not plausibly alleged that the Times published the article with actual malice. The Wayfarer party's claims also should be dismissed because they have failed to plead actual malice, which is required by New York's anti-SLAPP law. And then there's a footnote here. It says New York anti-SLAPP statute applies to this litigation because the Times conduct relates to free speech in connection with a public interest. Okay. At the pleading stage, the actual malice standard requires plaintiffs to sufficiently allege that a statement was published with knowledge that it was false, or that the publishers entertained serious doubts about whether it was true. Let's go on over this. The Wayfarer parties have failed to meet this high burden in 2 ways. First, to allege actual malice, a plaintiff must plead plausible grounds to infer actual malice by alleging enough facts to raise a reasonable expectation that discovery will reveal evidence of actual malice. Allegations of actual malice that are no more than pure speculation and are supported not by facts but by only conclusory statements are insufficient. Here, all the Wayfarer parties offer are actual malice buzzwords. Example, they plead the actual malice standard itself without any supporting facts. This allegation is plainly insufficient. That is especially so when the Times could see in Lively's CRD complaint an astonishing array of actual evidence of smear campaign that would have led any reasonable reader to conclude that the allegation was true. At the same time, in responding to the Times' pre-publication request for comment, plaintiffs' counsel failed to address that evidence or provide counter-evidence, in effect leaving Lively's evidence as the only evidence from which the Times would form a belief about the accuracy of the allegations. Second, in a case against a news organization, the state of mind required for actual malice would have to be brought home to the persons in the organization having responsibility for the publication. And they're citing a case here, Sullivan. Okay. Even if it could be argued that the Wayfarer parties have plausibly alleged the Times as an organization acted with actual malice, the Wayfarer parties have failed to plead any facts that could impute knowledge or falsity or subjective doubt of truth to anyone at the Times responsible for the article. Well, I guess it really depends on what all was said when they denied everything to the Times before the article was published, but I'm sure they'll lay that out on the next document.
Yeah. I mean, as long as nobody recorded you saying you just wrote a hit piece, maybe you're okay.
Oh, man. Okay. The absence of such allegations further dooms the Wayfarer party's defamation claim. Dooms. Wow, that's dramatic. The Wayfarer party's claim for false light invasion of privacy, asserted under California law, also fails. As discussed above, see Super at 6 to 8. New York law applies. Okay. But New York law does not recognize the tort of false light. Okay. Well, that would be, a very nitpicky legal thing, probably that I'm not going to get into. But it says the Wayfarer party's false light must therefore be dismissed. 5. The Wayfarer party's tag-along claims fail. Aware they have no claim against the Times based on the publication of the article and video, the Wayfarer parties assert tag-along claims for promissory fraud and breach of implied in fact contract. These claims also fail as a matter of law. The promissory fraud claim, it fails. Let's see, we have footnote 22 here. Let me make sure I didn't miss anything good. Yeah, so it's just talking about false light in California. To allege a claim for promissory fraud, the Wayfarer parties must show 1, that there was a material false representation, 2, made with knowledge of its falsity, 3, an intent to defraud, 4, that plaintiffs reasonably relied upon, 5, causing the plaintiff damages. But where a fraud claim arises out of the same facts as plaintiff's breach of contract claim, with the addition of only an allegation that defendant never intended to perform the precise promises in the contract between the parties, the fraud claim is redundant, and plaintiff's sole remedy is for breach of contract. See Global Text. Okay. Here, the Wayfarer party's promissory fraud and contract claims are premised on the same facts. The Times alleged promise to hold off publication until noon on December 21st, and I feel like there would be like some email evidence of that or something, probably, because they did, somehow reach out and ask for a statement. And their alleged decision to break that agreement and publish early. Okay. And that's what we saw in the amended complaint that they were talking about. Compare the first amended complaint with, and then the next document we're going to see. So can you read from here to the bottom of the page for me? Right there. Yeah. As such.
Yes.
I'll be right back.
Okay. As such, the Wayfarer parties' promissory fraud claims must be dismissed. And even if that were not so, plaintiffs failed to show that they had any intention of doing anything in the 2 hours between the publication and the deadline for comment. There was, in other words, no reliance on the Times setting of the noon deadline and no materiality to that representation. It had no effect fraudulently or otherwise. Okay, Section 5, Part B. The breach of contract claim fails. The Wayfarer parties' claim for breach of implied in fact contract also fails. In New York, a breach of implied in fact contract requires that a plaintiff allege, quote, the existence of a contract, the plaintiff's performance under the contract, the defendant's breach of that contract, and resulting damages, end quote. And there's a case citation there. Here, the Wayfarer parties claimed that the Times broke its agreement to forbear from publishing the article until noon on December 21st. Paragraph 380. But the actual correspondence between the parties contradicts these ill-formed allegations. On the day before the article was published, Ms. Toohey of the Times emailed Jennifer Abel offering until noon the next day to respond to the allegations, provide additional relevant information, and correct inaccuracies. And that's paragraph 386. That same evening, Abel replied to Ms. Toohey's questions and represented that the response was on behalf of Baldoni, Heath, Sarowitz, Nathan, and herself, the response. Okay, that's in Bolger Declaration Exhibit 4. Importantly, Abel did not indicate any desire to provide more information. The Times then quoted extensively from the response in the article and the video, and the article links to it in full. In short, the Times did what it told Abel it would do: provide the Wayfarer parties, I guess, probably the opportunity to do a response. Okay, so that's the end of that page. I know, what a generous offer, right? Yes, let's see. Read the original complaint. She endorses what New York Times says by claiming retaliation similar to the Victim Warrior article that sunk her case in the Amber Heard case. Okay. Let's see. Yeah. So Soggy Pizza Pie says they had it, which I guess was the original complaint draft, since October. So they had time, but chose to only contact the night before on a holiday. Interesting timing. Yeah, the details matter here, right? If when did they receive the draft? What were they doing between receiving the draft and writing the article? What investigative journalism were they doing? These are good questions. This is why a strict timeline is very important, I think.
Sorry about that. My boss needed me to do something real quick, and then she said I'll have to do something again in like 10 minutes, and then I'll be done for the day. So
Oh
I
my
might have to run
goodness.
out one more time in a second, but that's it. Okay, did you get through the page? Or
Yes, it is Friday.
it is Friday. That's true. Okay, so this was the breach of contract claim.
Mhm.
The Times quoted extensively from the response.
Yeah,
Okay,
so I
article
had gotten to
full.
provide the Wayfarer parties the opportunity to respond to the allegations.
Okay.
So their conclusion is there's no breach of any contract.
Right, gotcha. If anything, the Wayfarer party's confusion about what the Times had proposed, and all these parties are saying like these guys are just confused. They're just confused. They just don't understand. They misunderstood the subpoenas. They're just misunderstanding everything, which is kind of I feel like a little bit rude, but okay. About the Times had proposed showed there was never the requisite meeting of minds for the establishing of any sort of contract. In the complaint, the Wayfarer party suggests that the Times somehow promised to wait until noon to publish the story, but that promise is nowhere seen or implied in the correspondence, and is belied by the fact the Wayfarer parties provide a response in that time frame, did not indicate any intention to provide additional information, did not ask for more time, and most notably said nothing to the Times between Abel's email at 11:54 on p.m. on December 20th and the publication of the article at 10:11 a.m. on December 21st. The contract claim fails. Conclusion: the Wayfarer party's complaint tells a one-sided tale that has garnered plenty of headlines. But the Times does not belong in this dispute. For the foregoing reasons, the complaint should be dismissed with prejudice pursuant to Federal Rules of Civil Procedure 12b6 as alleged against the Times. Okay. And
Did
then
the Times
here,
write any of those attention-grabbing headlines?
just the ones in Blake's favor.
I guess. Oh my
I
gosh.
don't see any pro-Justin news on the Times these days, you know?
I sort of see what they're arguing. It's sort of like if I had a document and I said, "Hey, Lauren, can you review my document and send me editorial feedback?" And
No,
I
I'm
need all
busy.
your editorial feedback before the end of Friday,
Right.
5 p.m. Pacific or something.
Oh, man.
And let's say on Wednesday you send me some feedback on my document.
Hmm.
Now, the question is, can I just assume you're done providing feedback? Now, if I gave you like until Friday at 5 p.m., like I would be expecting you could send me another round of feedback between Wednesday and Friday, right? Whereas I think what they're saying is we went ahead and published before the end of Friday because we thought they were done giving feedback. And I think that's where the disagreement here is coming from.
Yeah. Isabel. Yes, I think Isabel is about to start a class action harassment suit against Mint Mobile for the Ryan Reynolds ads.
It's kind of amazing. Yeah, I don't know if they're doing that. If that's just the YouTube algorithm, like it's just procedurally like,
Yeah, I know.
oh, these people are talking about these keywords. We're going to throw
Mhm.
these Mint Mobile ads in here. Like, is
Yeah.
the YouTube algorithm just some robot somewhere is doing that? I don't know.
Hold on, let's see this. I want to skim through this and see what exactly we're looking at here. So we have the email that they were talking about. Do we have any of the text messages? What I really want to know, but okay, we can bury anyone. They've got their article there. Okay, Exhibit 2, video lodged in hard copy of the court. So they did file for leave to add that as a flash drive. So we don't actually have the physical thing, but it's marked there as.
Do you know what this
Exhibit 2.
video was? Is it just like one of these AI voices reading the article and they throw it on YouTube or something? Is
I
that
don't
what
think
that
it's
is?
I don't know if it's. I don't think it's an AI, but it is. Yeah, just like someone going over the.
Or some reporter reading
Yeah.
it, rereading the same content. So it
Right.
doesn't have anything substantially different in it.
Mm-hmm. This is a CRD complaint, I believe. Yes, it is. Okay. Exhibit 3, Part 2. Okay, more of the CRD complaint. Okay. Exhibit 3, Part 3. Good Lord. So this is all stuff we've seen before, guys.
Yeah, maybe there's a page limit on exhibits here,
Must be.
which would
Yeah.
be different from Arizona, where you can just put an entire court transcript as an exhibit.
I suppose so, yeah.
Thanks, Dave.
Mhm.
Jingris.
Yeah, right. Exhibit 3, Part 4. Yeah, more of that. More of that. Exhibit A. Okay. Here's where we got some stuff that we might not have seen before. I think. No, wait. This is from the complaint, actually. So no. These are exhibits from the complaint. That is their exhibit. So it's just confusing. Exhibit 4. Here we go. Okay. From Jennifer Abel, and it's to Megan Twohy from the Times. Copy to Brian Friedman and Melissa Nathan. Yes, and Jed Wallace. What? Okay.
I think it's going backwards. So that's the most.
Oh, okay.
That's the most recent email, and then
Yes.
the older emails are below.
Okay. Yeah. So we'll go from the bottom up then. Whoa. What the fuck? All right. Back up.
At least I think that's how it is.
Okay. So that's the start of the emails. Yep. You're right. Okay. From Megan, the writer for the Times. Miss Abel, we are reporting about a crisis communication operation conducted on behalf of Justin Baldoni, Jamie Heath, and Wayfair Studios to protect their reputations and harm Blake Lively as described in a legal complaint filed today. Okay.
It's funny that here they call it a crisis communication operation as opposed to a smear campaign.
Yeah, right. Yeah. Let's see. Our reporting found that you participated in the effort, which was undertaken last summer out of concern that complaints Ms. Lively had made during the filming of It Ends With Us would become public during the movie's rollout. We have learned that Ms. Lively filed the legal complaint against you, Mr. Baldoni, Mr. Heath, Steve Sarowitz, Wayfair, Melissa Nathan, and Jed Wallace, alleging sexual harassment, retaliation, and aiding and abetting of harassment and retaliation, among other claims. The complaint claims misconduct on the part of Mr. Baldoni and Mr. Heath during filming, including repeatedly violating physical boundaries and making sexual and other inappropriate comments. The complaint includes a side letter to her contract signed by Mr. Heath, in which the studio agreed to install more safeguards during filming and agreed not to retaliate against Ms. Lively. She's now saying they violated the terms of the letter. And we all know what letter they're referring to, that demand list, right? Let's see. The complaint includes extensive private text messages and emails that she obtained through a subpoena and that document the crisis communication operation. They include exchanges involving you, your team, Mr. Baldoni, and Mr. Heath. The New York Times reviewed these along with other documents. What other documents? We're seeking your response to the claims of retaliation through this PR campaign, and we would welcome the opportunity to talk with you on the record. Please offer any on-the-record comment as well as any other information you think we should know. Additionally, please notify us of any inaccuracies. We need to hear back from you tomorrow by noon Eastern. Among Ms. Lively's allegations.
What a deadline.
Yeah, right.
Tomorrow, what's happening at noon? Does they have to be at
Or
the tap
else.
house or something? Like, is it
The
early
tap
happy
house.
hour or something? What's going on here?
Oh my gosh. No, not the tap house. I mean, maybe that's where she was when she wrote this email, but I'm not sure. So, one second here. Where was I? In May, several months after the filming wrap, Mr. Baldoni was worried when he realized that Ryan Reynolds had blocked him on Instagram. We should have a plan for if she does the same when the movie comes out. Mr. Baldoni wrote you in a text message. Plans make me feel more at ease. I mean, that's... So? Okay. You were already working as a publicist for Mr. Baldoni and Wayfair. Mr. Baldoni and Mr. Heath hired Melissa Nathan, a crisis communication specialist, who in turn brought in Mr. Wallace. The plan was to harm Ms. Lively's reputation. Ms. Nathan
Whoa,
shared...
that's a
Yeah.
that's big. It's not like the complaint alleges that the plan,
Mhm.
this is this person making this claim.
Yeah, no, that's pretty crazy. Hang on one sec. Just gonna put this in here real quick. Sorry, I'm trying to select something. Okay. Ms. Nathan shared a planning document in early August describing options to pursue if Ms. Lively of her team went public with complaints about Mr. Baldoni and Mr. Heath's behavior. She suggested talking points to use with reporters, including that Ms. Lively used an imbalance of power to take creative control of the film. Again, I don't really see anything particularly wrong with that, because the assumption they're using is that all of this was to harm her behavior and not to kind of help him navigate the obvious kind of shitstorm they're going to bring down on him, in my opinion. So,
What started this bullet list? Can we see that paragraph above this one more time?
this one?
Uh-huh. Okay, so I mean, they're getting out of it because they say among Ms. Lively's allegations. So
Okay.
that's fair.
Let's see.
That's from Callie with love. Thank you.
Mr. Baldoni wanted more. You wrote to Miss Nathan, I think you guys need to be tough and show the strength of what you guys can do in these scenarios. He wants to feel like she can be buried. Ms. Nathan responded, of course, but when we send over documents, we can't send over the work we will or could do, because that could get us in a lot of trouble. We can't write it down to him. We can't write, we will destroy her. Imagine if a document saying all the things that he wants ends up in the wrong hands. Well, that would be a little uncomfortable right now, wouldn't it? We can bury anyone, she added, but I can't write that to him. Okay. 3 days later, Mr. Baldoni texted you, flagging a social media thread that accused another celebrity of bullying behavior and that had generated 19 million views. Mr. Baldoni wrote, this is what we would need. Okay, so just to kind of put that into some context, he's expecting them to try to ruin his reputation based on their behavior when they tried to take over the movie, if we're to believe, what happened on his side. And so is it really so outlandish or threatening to think that, like, he would hire someone to help him point out that, hey, this is not exactly what happened? You know what I mean? Like, it doesn't seem like that's done with malicious intent. It's more like, okay, I know what's coming and I need someone to help me. Like, I need some help for this. I'm not convinced that he ever would have, done anything like this, like, or hired anybody to help with his image problem if they had never gone and, like, done things to make him look bad anyways, like make him watch the premiere in a basement and not have him anywhere around the cast during the promotion for the film. So he's got to have, like, in his mind at some point, like, hey, I know this isn't going to end well. So again, I really feel like that's more of a defense than it is an attack mechanism or a start of a smear campaign. It's more of a, hey, like, please don't, ruin my life. So I don't know. That's just kind of my thought process. Stephanie says, what subpoena? They keep saying that, but nobody's seen it. What do you mean?
Well, up above in this email, they mentioned that this is where they're getting these text messages. That's the source, right? So if you go to the top of this email.
Yeah. The top, like right here?
Well, somewhere up here. So it's the final paragraph here. The complaint includes extensive private text messages and emails that she obtained through a subpoena.
Mm-hmm.
So
okay.
Where is that subpoena? Do we have it? I don't know.
So when I was reading the court transcripts yesterday, so most of you guys who are watching this might have seen it. I was reading the court transcript from the February 3rd meeting, and that was not publicly available yet. That's not actually going to be publicly available for download until May. I had to go to the court website, find the number and contact information for the court reporters, and then I messaged them, and I was basically like, I've never done this before, so I emailed them, and I was like, hey, am I allowed to request this? And they said yes, so I paid for it. But anyways, that document, the lawyers for one of the publicists on Justin's side, they were saying that Blake's side, the publicist, had already gotten subpoenas, and they had been served, and they had already gotten discovery back. So that must be it. Unless somebody else in the comments can explain how that happened. So that must be the subpoena they're referring to, I guess. I don't know. That's all I can.
Sure.
Yeah. That's all I can think of. I could totally be wrong on that, but that's the only subpoena I can think of that was executed that we didn't know about. And it's because it happened in that closed door meeting on February 3rd that they were talking about it. And yeah, so I don't know. Maybe someone else has better information. So anyways. All right. Which one were we on here?
Never hand over your phone or laptop to somebody in a conference room.
Oh, fuck that. Mm-hmm. So That is if it really did come from a subpoena and not from that cell phone. So we're operating on the assumption that that's actually how she got that information.
Yeah.
And I'm not convinced that that's true.
Right.
So, it could just be a fucking lie, you know, but we don't know. So, I think you guys can be tough. We went through that. Where did we get to? We got through this part of the 19 million views. Yep. Ms. Nathan presented proposals to hire contractors to dominate social media through full social account takedowns by starting threads of theories and generally working to change the narrative. If you can read some of this page, I'm going to look up really quickly in that other docket just between the publicists to see if those subpoenas are there.
Okay.
Okay.
Okay, so these are again all things that the Times is trying to get feedback on before noon tomorrow. The first one here on page 5, you wrote to Ms. Nathan, I think we need to put the social combat plan into motion. And she responded, so do I. The team worked to block stories about Mr. Baldoni's behavior that had concerned Ms. Lively and reinforced negative ones about the actress. The press coverage probing Mr. Baldoni's separation from Ms. Lively and the rest of the cast was largely vague and didn't include the most serious allegations against Mr. Baldoni. Ms. Nathan texted you, he doesn't realize how lucky he is right now. We need to press on him just how fucking lucky. Okay. The whispering in the ear, the sexual connotations like JFC, other members feeling uncomfortable watching it. I mean, there is just so much. Okay. Ms. Nathan indicated that she succeeded in keeping allegations against you out of stories and wrote in one text that major news outlets were standing down on HR complaint. You wrote to Ms. Nathan, so are we in the clear now? Did we survive? And she responded, we survived. All press is so overwhelming. We've confused people so much, mixed messaging. It's actually really funny if you think about it. Under the official promotion plan, Ms. Lively focused on the uplifting nature of the film rather than abuse. When the PR team saw that critics accused her of being tone deaf, the group decided that Mr. Baldoni would highlight survivors of domestic violence. Is that the timeline? I'm not sure. There are references in emails to social manipulation and proactive fan posting, and text messages cite efforts to boost and amplify online content that was favorable to Mr. Baldoni or critical of Ms. Lively. Ms. Nathan sent you a comment from Mr. Wallace that we are crushing it on Reddit. I mean, everybody wants to crush it on Reddit, right? The next day, one of her employees texted, we've also started to see a shift on social due largely to Jed and his team's efforts to shift the narrative. Ms. Nathan wrote to you, and socials are really, really ramping up in his favor. She must be furious. It's actually sad because it just shows you have people really want to hate on women, or I think they meant how people really want to hate on women. When a TikTok sleuth started asking questions about Mr. Baldoni, you texted that we flagged to Jed and his team for more serious action.
Not a TikTok sleuth. Not a TikTok sleuth. Okay.
Oh, justice for our TikTok sleuths. Okay. We flagged to Jed and his team for more serious action on the social side. Okay. And then you wrote to Ms. Nathan something on the next page. Did you find what you were looking for, Lauren? Oh boy, this is a big email. Here's my wall of text email. Get back to me by noon tomorrow. Oh, stressful. The narrative online is so freaking good, and fans are still sticking up for Justin, and there literally has been no pickup on of those 2 articles, which is actually shocking to me, but I did see as a total success, as does Justin. You did such amazing work. Ms. Nathan responded, narrative is crazy good. So did you. The majority of socials are so pro Justin, and I don't even agree with half of them. LOL. Oh, geez. Mr. Baldoni periodically looked for assurances that the crisis team was not deploying bots. Ms. Nathan wrote that they were not using bots and that Mr. Wallace's operation is doing something very specific in terms of what they do. I know Jamie and Jed connected on this. It's good. On August 16th, when Ms. Nathan shared a Daily Mail article headlined, is Blake Lively set to be canceled? You responded, wow, you really outdid yourself with this piece. And Ms. Nathan wrote, that's why you hired me, right? I'm the best. The manipulated media coverage and online commentary became an unusually high percentage of Miss Lively's online presence. She was branded tone deaf, difficult to work with, and a bully. Sales of her new hair care line plummeted. Oh, jeez. Sincerely, Megan Tui, reporter, New York Times. New York Times is very concerned about hair care products, guys.
Dude.
Oh my gosh, where is this email thread going to go?
Oh man, I don't know, but real quick, I just wanted to point out to everybody what I was talking about with the subpoenas. I couldn't find, so I didn't see anything about that on the docket, but here, let's take a look at it, what was said to the judge in between the attorneys. So this Miss Toller here is the attorney for Abel. And this is where Brian Friedman is talking. Says, thank you, Your Honor. On behalf of Jennifer Abel, which is also a woman-owned company, because they were trying to say that, how dare you, basically in other words, but like, basically I'm paraphrasing, why would you drag my client's woman-owned business through this? They don't need to be a part of this lawsuit. And that was for like Blake's publicist. So he was also throwing in there, hey, by the way, this publicist company too is also a woman-owned company. So I'm not sure why you're saying that. Okay, so I want to stress something that you might not know, Your Honor, which is that Ms. Jones and Jones Works filed in the Supreme Court in New York. They had that case, which has been now removed. Oh, that's why. I have to look for that case, not the one that I was just on. But I'll do that after the stream, guys. They immediately conducted discovery in that case. As a matter of fact, they served subpoenas in that case. And even though we removed the case, apparently there were significant responses to those subpoenas, which I don't know whether we've seen them or not. I know that something came over the email this morning, but I haven't looked at it closely. So they were very eager to move quickly and start discovery very quickly, and in fact got responses to discovery. So maybe that has something to do with it, guys, but it could be totally unrelated. I'm not positive. I'm just wanted to point that out, that we did see that yesterday. Okay. Right. So this is we're going up because it's going backwards.
And remind me of the date of the original email, date and time.
December 20th at 6:46 p.m. And remember, they were like, tomorrow, but by noon tomorrow, you need to, tell us. Yeah. So, okay. We have on Friday, December 20th at 11:16 p.m. So 4.5 hours later, Jennifer Abel wrote, Megan, please see the on-record statement that must be included in full, attributed to the attorney for Justin Baldoni, Wayfair Studios, and all its representatives, Brian Friedman. It is shameful that Ms. Lively and her representatives would make such serious and categorically false accusations against Mr. Baldoni, Wayfair Studios, and its representatives as yet another desperate attempt to fix her negative reputation, which was garnered from her own remarks and actions during the campaign for the film. Interviews and press activities that were observed publicly in real time and unedited, which allowed for the internet to generate their own views and opinions. I agree with that. These claims are completely false, outrageous, and intentionally salacious, with an intent to publicly hurt and rehash a narrative in the media. Wayfair Studios made the decision to proactively hire a crisis manager prior to the marketing campaign to the film to work alongside their own representative with Jones Works employed by Stephanie Jones, due to the multiple demands and threats made by Ms. Lively during production, which included her threatening to not show up to set, threatening to not promote the film, ultimately leading to its demise during release if her demands were not met. It was also discovered that Ms. Lively enlisted her own representative, Leslie Sloan, with Vision PR, who also represents Mr. Reynolds, to plant negative and completely fabricated and false stories with media, even prior to any marketing had commenced for the film, which was another reason why Wayfair Studios made the decision to hire a crisis professional to commence internal scenario planning in the case they needed to address. The representatives of Wayfair Studios still did nothing proactive nor retaliated, and only responded to incoming media inquiries to ensure balanced and factual reporting and monitored social activity. What is pointedly missing from the cherry-picked correspondence is the evidence that there were no proactive measures taken with media or otherwise, just internal scenario planning and private correspondence to strategize, which is standard operating procedure with public relations professionals. Okay, and then she responds at 8:52. Doesn't make sense. It must be because of the different time zones. So that would be what, 11:52? Yeah. And this is from Megan writing back. Thank you for your response. Can you kindly clarify who is represented by this statement? Is this statement on behalf of Mr. Baldoni, Heath, Sarowitz, you, Miss Abel, and Melissa Nathan? Who is CC'd on this message? Please let me know. Yes, and Jed Wallace. So that's where that came from. Okay, so that was all the correspondence, I guess, before the article came out.
Mm-hmm.
I mean, did they say anything else, or were they planning on saying anything else? I don't know. You know. All right, let's see this next exhibit. Exhibit 5. Oh. Okay. From Megan to, and then it's redacted. I guess it's to Justin though, because it says Mr. Baldoni. They just want to hide his email. Urgent questions from the New York Times, and this is at 9:38 p.m. on December 20th. And remember, an original email to the publicist was at 6:46. So this is a few hours after she sent the email to the publicist and some others. Okay. Mr. Baldoni, we are reporting about a crisis communication operation conducted on behalf of you, Jamie Heath, and Wayfarer Studios to protect your reputations and harm Blake Lively's as described in a legal complaint filed today. The effort was undertaken last summer out of concern that complaints Ms. Lively had made during the filming of It Ends With Us would become public during the movie's rollout. We have learned
Is
that
this
Ms.
just
Lively...
a copy of the other email? Like they're
I
just
don't know.
sending the same. Is this the same text?
Let's see. It could be. Hang on. Side letter to your contract. This one just has bigger text, I think. Wait. So she didn't include, I don't think, all this stuff in that one, but let's see. Is it a side letter? Yes, it is. Thank you. I would have read that all again. Oh, no, she did. She did.
Yeah.
It's just smaller here. The text is smaller.
Yeah, I mean, sometimes if you send an email and somebody replies and you go, but the font may change depending on whether you're looking to reply versus, then you create a new email, copy paste. That's probably what's happening here.
Okay. I don't know why they included that twice then, or in separate exhibits. It's kind of weird.
They're probably just putting that to prove that they sent it to both people.
Did she say this up there? The unfollow situation is what everyone's pointing at. Let's see. I think she did. Let's just double check. No, this is different. So just the bottom is different, I guess.
Yeah, it could be.
Because it looks like she's asking him directly about stuff that he reportedly said. So it's just the bottom here. Okay, so after TikTok sleuth came, you worried that the unfollow situation is what everyone is pointing at, seemingly that something is much bigger under the surface, as why would they all unfollow? And a member of the PR operation responded, we flagged to Jed and his team as well. You periodically looked for assurances that the crisis team was not deploying bots. Ms. Nathan wrote that they were not using bots. Lots of talk about bots. Bacon bots. And that Mr. Wallace's operation is doing something very specific in terms of what they do. I know Jamie and Jed connected on this.
Yeah, we saw that before.
On August 16th, when Ms. Nathan shared a Daily Mail article headlined, Is Blake Lively Set to Be Canceled? Ms. Abel responded, wow, you really outdid yourself with this piece. And Ms. Nathan wrote, that's why you hired me, right? I'm the best. And that's, guys, remember that when we actually saw this in context, we saw that Abel was being sarcastic. Or not Abel, sorry. Nathan was being sarcastic. And so, or they were both being sarcastic. So, they saw a piece and they were like, yeah, wow, you really outdid yourself with this one. And she was like, oh, yeah, totally. But it wasn't, they were using sarcastic emojis and saying basically they were joking about it. It wasn't actually her, but they were going to be accused of that, basically, is kind of what I gathered from that. At least that was
I would say about
90%
of the conversations I might have in the hallway with my senior employees when I was a manager were of a sarcastic tone.
Yeah.
It was our coping mechanism, right?
Yeah. I don't know. I feel like this is just, it would be incredibly stupid to say that and be totally 100% serious in writing. It sounds like they know that they can't say certain things in writing. So obviously it lends more credibility to the fact that this was total sarcasm. And these were friendly coworkers or colleagues or even just friends, joking back and forth with each other.
Yeah, I mean, I've seen things where, people are making technical presentations to share with customers at a job. And, the more senior people or the more experienced people are like, okay, here are these things we can't say about our competitor, even if we think it's true, even if it's our opinion. There are certain things you just don't do as a matter of protecting your liability.
Yeah.
And so when you're at work, you talk about those things. It doesn't mean you're going to go do them, even if you believe them to be true, right?
hmm Yeah. I mean, maybe not. All right. Let's see. The manipulated media coverage and online commentary became an unusually high percentage of Miss Lively's online presence. I mean, she was branded tone deaf, difficult
Yeah.
to work with, a bully. Sales of her new hair care line plummeted.
Yeah.
That's what we saw that above.
This is the
but-
same thing
Yeah.
as before.
So the only thing that was really
Um,
different was that part right there.
Somebody in chat mentioned they didn't think the hair care line was very successful to begin with. So plummeting
No.
might not. For example, I teach this to a lot of new engineers. They'll go get some data and like something that happens 4 times will suddenly happen twice.
Mhm.
And they'll say, oh, the amount of times this happened got cut in half. And you're like, wow, that sounds really big. But then if you look at other instances of those events, it could like, what if you're looking at a million things?
Yeah.
A 4 going to a 2 is just noise. So who knows, right?
Yeah.
What does
right.
plummeted mean? It could just be noise.
Let's see. Exhibit 6. What is this? Mr. Heath. So this is the same kind of email she sent to Mr. Heath. Let's see if any of the bullet points are different, but I doubt it. During shooting, she brought complaints about alleged sexual and other inappropriate conduct. Is this different? I think it might be. About the wife naked and stuff.
Yes.
Okay. She claimed that you had shown her a video of your wife naked and that you had watched her in her trailer when she was topless and having body makeup removed despite her asking you to look away. So the thing about the video of the wife naked, we have actually seen that in the exhibits on Justin's amended complaint, and she was not in fact naked. So Bruce and I have talked about this before. Neither one of us would really want to see a coworker's wife in that situation, but that's really a personal thing. Maybe some people would be okay with that. And generally speaking, with like regular everyday jobs like that we have, like, or in corporate world or whatever, you're not going to go show your coworker something like that. So like, it's a little weird to us, but maybe in like a more creative, less strict setting, I don't know, people are like that. And I know they did ask her, would you want to look at this? But the thing is, like, even if she had said, no, I don't want to see that, she's misrepresenting what actually happened when she says she was naked, because we all saw that she was not. So, okay. Okay. She alleged that throughout filming, you and Mr. Baldoni invaded her privacy by entering her makeup trailer uninvited while she was undressed, including when she was breastfeeding her infant child. She claimed that Mr. Baldoni had improvised unwanted kissing with her and discussed his sex life, including encounters in which he may not have received consent. And I have yet to really see anything pertaining to that makes any sense at all. So that really seems like it was kind of pulled out of thin air. Mm-hmm. Your studio, Wayfair, agreed to provide a full-time intimacy coordinator, bring in an outside producer, and put other safeguards on set. In a side letter to Miss Lively's contract, your studio also agreed not to retaliate against her. So I feel like they definitely would have loved to have had more than, a little over 12 hours to put together a real response to all of this. So it's kind of shitty that they just ambushed them with this the day before or the night before.
This is a lot of
just
material, and it's
Mhm.
not a lot of time to respond. And
Right.
the other thing, the vibe you get here is these are such serious allegations in this original complaint, right?
Mhm.
That would you want to write an article without really getting into this? Now, it's one thing if you're just TMZ and you write a paragraph, hey, some complaint hit a docket.
Right.
It's crazy. Okay, fine.
Yeah.
Thank you.
Well, then you're going to write 13 more with little snippets every time to get more traffic.
If you're going to start, writing your own larger format article or like some sort of Rolling Stone expose or something, you need to do a lot more legwork with these people other than tomorrow at noon.
I mean, maybe they expected that they would later communicate some more with them to get another huge article out with more details, but instead they got served with a lawsuit. I don't know. Maybe they were expecting them to respond more, but instead they got pissed off and now they don't want anything to do with the New York Times. So maybe just they made an assumption about how this was going to go and it backfired. I don't know. But that's pretty crazy still. I can't imagine being a major publication like this and having the opportunity to tell exclusively both sides of the story and just foregoing that opportunity for funsies. Like, I don't know. Someone explain that to me. Tharuna, thank you for becoming a YouTube member. I appreciate you. I hope I said that right. I don't know if it's Tharuna or the Runa. So I hope I said it right.
And
Thanks.
they already admitted in this filing, right? They weren't like racing to be first to publish. They admit that TMZ already mentioned that this filing had been submitted.
Yeah. Cat says, those promotional pictures were horrible. I don't want frizzy, dry hair. My hair does that without your shitty products.
Wow.
Oh, man.
Oh, dear. Buy Moose brand shampoo. It's the best.
Oops, my bad. That means I'm supposed to do something with my boss. It's going to take like 5 minutes. Hang on, give me 1 sec. Well, maybe less than 5 minutes because I just have to send an email real quick. Where were we here? We got past this, right? Yes, we did. And then Miss Lively expressed concerns about him from the very beginning. Before shooting, she objected to some sex scenes that he wanted to add that she considered gratuitous.
Oh, boy.
Okay. Some of this stuff, like towards the bottom, might be the same. I don't know. Did they mention the Colleen Hoover stuff in the other emails?
I don't think so.
Okay. Can you read from here just to the bottom, and I'll be right back. This won't take very long. Sorry.
Okay. We will do what we can. Okay, so we're at the top of this. This is page 116 of 127. We're almost there, guys. With the support of Sony, the film's distributor, she made her own cut of the movie, bringing in editors and a composer and adding in a Taylor Swift song. Wayfarer and Sony went with Ms. Lively's cut, and she got a producer credit. Oh, my. The Reputation campaign. In May, several months after the filming wrapped, Mr. Baldoni was worried when he realized that Ryan Reynolds had blocked him on Instagram. Oh, my gosh. As far as I know, Ryan Reynolds has not blocked me on Instagram, so that's good. Let's see. We should have a plan for if she does the same when the movie comes out, Mr. Baldoni texted Jennifer Abel, a member of the PR team. Plans make me feel more at ease. Yes, planning is good. All right, what else do we have? Before the release of the film, Colleen Hoover, Ms. Lively, and other cast members informed Sony and Wayfarer that they would not do any publicity appearances alongside Mr. Baldoni during the rollout of the film. Ms. Hoover had experienced frustrations with Mr. Baldoni and became upset when he told her about Ms. Lively's allegations at a dinner last spring. That's interesting. You and Mr. Baldoni hired Melissa Nathan, a crisis communications specialist, who in turn brought in Jed Wallace. The plan was to harm Ms. Lively's reputation. Oh, boy. Ms. Nathan sent you and Mr. Baldoni a planning document in early August describing options to pursue if Ms. Lively or her team went public with complaints about your and Mr. Baldoni's behavior. She suggested talking points to use with reporters, including that Ms. Lively used an imbalance of power to take creative control of the film. Mr. Baldoni wanted more. Ms. Abel wrote to Ms. Nathan, I think you guys need to be tough and show the strength of what you guys can do in these scenarios. He wants to feel like she can be buried. Ms. Nathan responded, of course, but when we send over documents, we can't send over the work we will or could do because that could get us in a lot of trouble. We can't write it down to him. We can't write, we will destroy her. Yeah. So they're trying to just do a professional job here. Imagine if a document saying all the things he wants ends up in the wrong hands. Right. So they're trying to do their job in the proper way. Again, we're scrolling up. Okay, that's good. We can bury anyone, she added, but I can't write that to him. 3 days later, Mr. Baldoni texted Miss Abel flagging a social media thread that accused another celebrity of bullying behavior and that had generated 19 million views. He wrote, this is what we would need. Okay, so he's just trying to find other examples. Ms. Nathan presented proposals to hire contractors to dominate social media through full social account takedowns by starting threads of theories and generally working to change narrative. The team worked to block stories about Mr. Baldoni's behavior that had concerned Ms. Lively and support negative ones about the actress. The press coverage probing Mr. Baldoni's separation from Ms. Lively and the rest of the cast was largely vague and didn't include the most serious allegations against Mr. Baldoni. Ms. Nathan texted, he doesn't realize how lucky he is right now. The whispering in the ear, the sexual connotations, she wrote, adding, I mean, there is just so much. Ms. Nathan indicated that she succeeded in keeping allegations against Mr. Baldoni out of stories and wrote in one text that major news outlets were standing down on her HR complaint. Under the official promotion plan, Ms. Lively focused on the uplifting nature of the film rather than abuse. When you, Mr. Baldoni, and the PR team saw that critics accused her of being tone deaf, the group decided Mr. Baldoni would highlight survivors of domestic violence. And I think we've seen he kind of had that whole intention the entire time, not just at the end there. Okay. And then we're on page 5 with her final questions to him. These are questions from Megan Toohey trying to get all of the members of Team Baldoni to reply with their comments before noon tomorrow. There are references in emails to social manipulation and proactive fan posting and text messages cite efforts to boost and amplify online content that was favorable to Mr. Baldoni or critical of Ms. Lively. Ms. Nathan sent Ms. Abel a comment from Mr. Wallace that we are crushing it on Reddit. We've seen that. The next day, one of her employees texted, we're also starting to see a shift on social due largely to Jed and his team's efforts. Ms. Nathan wrote to Ms. Abel, and socials are really ramping up in his favor. She must be furious. It's actually sad because it just shows you how people really want to hate on women. When a TikTok sleuth started asking questions about Mr. Baldoni, Ms. Abel texted that we flagged to Jed and his team for more serious action on the social side. Okay. These are very similar bullets. Let's see if there's anything new in this particular email. Mr. Baldoni periodically looked for assurances that the crisis team was not deploying bots. Ms. Nathan wrote that they were not using bots and that Mr. Wallace's operation is doing something very specific in terms of what they do. I know Jamie and Jed connected on this. On August 16th, when Ms. Nathan showed a Daily Mail article headlined, is Blake Lively set to be canceled? Ms. Abel responded, wow, you really outdid yourself with this piece. And again, this is the sarcastic tone. And Ms. Nathan wrote, this is why you hired me, right? I'm the best. Flex. The manipulated media coverage and online commentary became an unusually high percentage of Ms. Lively's online presence. We've seen this before with the tone deaf branding. And of course, this. I love how the final message here is, again, to every single person, sales of our new hair care line plummeted.
It's really important about the hair care line, guys.
Oh my goodness.
Women in America everywhere have ugly hair because this hair care line failed.
What have we done? Oh no.
Oh man. Oh, sorry, I'm still at the computer. I just couldn't come back on the mic yet. So I'm all good now. I was able to sign out of work, so I don't have to leave again.
TGIF.
Yeah. Lily May says, hi, whose document is this, please? We're reading over exhibits from the New York Times, who just filed a motion to dismiss Justin Baldoni's complaint. And so these are some emails they've attached to it. And then I saw somebody said, whoa, that's new, but I didn't know what they were talking about.
Oh, yeah. Some of these, it's interesting how obviously they have to tailor these emails to these different people because some of the bullets are about something that person said, whereas somebody else wouldn't be able to answer that question. So there's a lot of copy paste here, but there's also some unique things. And so this is from the New York Times reporter trying to sort of survey Justin Baldoni's team, but with very little time before their deadline.
Okay. Let's see. What do we got next here? Oh, more emails, bro. Okay, Ms. Nathan. Okay, so this was to Ms. Nathan. So she really did send like separate fucking emails to everybody.
Yeah.
All right. Maybe it'd be easier just to CC next time. I don't know. So she's asking these people, like, it looks like the bulk of the beginning of the emails are all the same. Pretty much. Let's see.
I think if you look through the bullets, I think it's pretty easy now to figure out which ones are unique versus copied. Because, for example, this one has something here about Johnny Depp and Amber Heard. That might be unique to this email, actually.
Yeah, I think it is because I never saw that before. But okay, just in case, I'm going to skim through this really quick. Slightly filed link, complaint because side letter to contract. Yeah, extensive private text messages. Yep. And yep. Okay. So, first bullet point for this one says, you have worked with high-profile clients, including Johnny Depp, whose ex-wife, Amber Heard, accused him of physical abuse. He successfully sued Ms. Heard for defamation, and the trial became a spectacle. I was about to say, how did that turn out? Is that really what you want to do here? And the trial became a spectacle amid suspicions of an online campaign to damage her credibility. In the text messages, you reference your involvement in that campaign. Can you comment on your involvement and what was done? Okay. This year, after a decade at the New York consultancy, Hilt 6 Strategies, you started your own firm, Tag PR. Its majority stakeholder is a company run by the prominent music manager Scooter Braun. I know that name. Mr. Baldoni and Mr. Heath hired you, and in turn, you brought in Mr. Wallace. You sent Mr. Baldoni and Mr. Heath a planning document in early August describing options to pursue if Miss Lively or her team went public with complaints. Well, that's responsible for a PR firm. So, Mr. Baldoni wanted more. Jennifer Abel wrote to you, I think you guys need to be tough and show the strength of what you guys can do in these scenarios. He wants to feel like she can be buried. Okay. Of course, but when we send over documents, we can't send over the work. We saw that.
We've seen all these.
Okay. So it was just the first one. I guess that was new. Did we see this one? Reckless thoughts of wanting to plant pieces? Okay. Let's see it. We'll look at this too. Miss Abel wrote to you, I think we need to put the social combat plan into motion. And you responded, so do I. You worked to prevent stories about Mr. Baldoni's behavior that concerned Miss Lively and reinforce negative ones about her. When Miss Abel wrote to you August 4th that I'm having reckless thoughts of wanting to plant pieces this week of how horrible Blake is to work with just to get ahead of it, you replied that you had spoken off the record to an editor at the Daily Mail and wrote that she's ready when we are. I don't know. This sounds like something that I might say to somebody in jest in private, honestly. Like I'm having reckless thoughts about this. I say things like I'm having intrusive thoughts, and then I say something ridiculous. So it sounds like it could, again, be said in jest, but I'm not positive.
It also depends on if those stories are legit. Like if you have an actor or actress who legitimately wants to tell their story that, hey, I had a horrible time working with this person. I mean, there's nothing inherently wrong with publishing that story.
Yeah. Gotcha. Let's see. Press coverings. I think we saw that one. Press coverage probing Mr. Baldoni's separation, and the rest of the cast was mostly vague and didn't include the serious allegations. We saw that. The whispering in the ear, the sexual connotations, like Jesus fucking Christ. Other members feeling uncomfortable watching it. I mean, there's just so much. What? What is that referring to?
We've seen this. Which one?
This here, the whispering in the ear thing. What is that referring to?
So the way I interpret this is this was this person, this PR person, responding to the allegations and just saying there's a lot of allegations. Holy crap. Like we've got a lot to deal with. Whereas I think they're trying to present it as, hey, even your PR people think these allegations are real or something, or they're admitting they're real, which I don't, you take it out of context. I don't think that's what is here. I think they're just saying there's a lot coming at us right now. That's the vibe I'm getting.
Yeah, no, definitely. Sorry. Wow, I spelled that wrong. Okay. Let's see. We got that. Writing in one that major news outlets were standing down. We saw that, right? Standing down on the HR complaint.
Okay. Yeah, I think we've seen
all of this.
All of these. Yes, we've seen all of these.
What about this one?
We didn't see the thing about Kirsty. I'm saying her name wrong.
Hang on. Where is it?
Kirsty. Second to last bullet.
Oh, Kirsty Flaw. Yeah.
Kirsty, I think is how.
Yeah. She's the one that the baby bump thing happened with. You seen that clip?
Right.
She's on YouTube. You watch her YouTube channel?
Oh, yeah.
Well? Yeah.
I've seen several of her follow-up videos. Yeah.
She's funny, dude. She's got congrats on your little bump shirts now.
she talked with Dave Neal. They did.
Oh, good. Okay.
Interviews with each other.
Usually I watch all of Dave's stuff, but the thing is, like, I've been so busy either reading a fucking document or working that I haven't had much time at all.
It's a lot.
I'll get to listen to like the podcast and stuff like while I'm working, but other than that, I've missed so much. I feel like because I'm too busy reading. Okay. In August, Kirsty, a Norwegian I hope I'm saying her name right. The first name.
I think it's like Kirsty.
Kirsty. Okay.
I think.
A Norwegian entertainment reporter uploaded to YouTube a 2016 interview she had done with Miss Lively, in which the actress snapped back when Miss Flaw made a comment about her baby bump, titling it "The Blake Lively interview that made me want to quit my job." What does that have to do with them? And also, we all saw what happened there. So, in 2022, in the midst of Mr. Depp's legal battle with Miss Heard, Miss Flaw posted clips of her interviews with the actor tagged "Justice for Johnny Depp." What exactly, again, is the purpose of this? That has nothing to do with.
I'm not sure. I mean, I think they're just saying, "Hey, these things happened. Do you have any comment about it?"
Um, again, like we said earlier, if you want this like a really thorough response to all this, you got to give them more than hey before noon tomorrow. And then they also published it a little after 10, so they didn't even give them the full time. So
Right.
you know, even if it's not illegal, even if it turns out being dismissed, I still think this is kind of scummy. I think it's scummy practice.
I think the interesting thing is in their legal arguments, they're like, "Hey, this one person replied to us,"
Seriously. Okay.
and then they're like, "So we were done." Whereas what these exhibits are proving is they sent questions to lots of people, and it appears that they did not get responses from these other people, even if they did get a response from one person.
Mhm.
That's interesting.
Gotcha. Okay, let's see. We got Exhibit 8 to Sarowitz. Let's see if she said anything different to Sarowitz.
Oh, geez.
Oh, okay. Okay, hang on.
There's so many of these.
It looks like the beginning might be a little bit different on this one. This one, not so much. We've seen that.
Mm-hmm.
We've seen that. We saw that. A side letter to her contract. We saw that. We saw that. And here it says specifically the legal filing asserts that you, Mr. Sarowitz, diverged at the film's New York premiere on August 6th that you were prepared to spend $100 million to ruin the lives of Miss Lively and her family. It also says you were among the non-essential persons present on set during filming of a birth scene involving Miss Lively. And that's obviously heavily disputed within Justin's lawsuit. So.
Mm.
And that you suggested flipping the narrative on a positive story about Miss Lively and her husband. We are seeking your response. I noticed there's nothing about Hamas in here. It was just nice. Yeah, right. We are seeking your response to the claims of misconduct and retaliation through this PR campaign. And we would welcome the opportunity to talk with you on the record. But does it have to be by noon tomorrow? Yeah, it does. Oh my God. Please offer any on the record comment as well as any other information you think we should know. Additionally, please notify us of any inaccuracies. We need to hear back from you tomorrow by noon Eastern. Okay. What day was December 20th? What day of the week? Friday. So she's emailing all these rich, busy people on a Friday night.
Yeah.
At almost 10 p.m. saying, by noon tomorrow, you better give me everything you want to say about this.
Wow.
And these people probably aren't even checking their fucking emails at that time of the literal weekend. Like, nobody's working on the... Well, they might be working. You know, they might check their emails for work and stuff like that. But still, almost at 10 p.m. on a Friday...
Yeah, you're not going to be able to reply by noon tomorrow. I mean, you need your boss, you need, your lawyer, you need Magnum PI, you need I mean, it's just, this is a lot. This is a lot to deal with.
Omar, the Tilted Lawyer's in the chat. Omar, if you want to come on and talk about, answer some legal questions for us, you can. You don't have to, though. So again, even if what they said in their motion to dismiss rings true, and even if it is dismissed, what I gathered from these emails is that while you can, work within these confines and maybe you can get away with it, this is a scummy practice. I really feel like this is scummy. I really feel like they dropped a bomb on these people on a Friday night and were like, by the way, you have like a little over 12 hours to decide. You better not sleep, because if you do, you won't have time to say everything you want to say. And it's just like, I don't know. It's really shitty. Oh, and it's right before Christmas, Susan says. And then they published 2 hours earlier.
That's right.
Yep. My God, dude. Anna Fan, thank you for the $5. I support Lauren and Kirsty. Thank you very much. What about Bruce, dude? I support Lauren and Kirsty. Thank you, Anna.
I'm just here to help.
Twice. Kai, thank you for the $2.79. It's through the night and 5 days from Christmas. That's right. So who knows where they are in the world at that point, anyways? Unless they're working on a project or something, but still. Guys,
we
Omar's
need
gonna be doing the stream.
we need to get Omar, the Tilted Lawyer, to become a defamation case expert and help us out here.
For sure.
And I would love to dress up as Magnum PI, but I don't have enough chest hair.
I mean, you could get some confetti or something.
Some glitter.
Maybe use some of Blake Lively's hair care spray.
Oh my.
Man. Yeah.
Ugh.
Guys, if you
fluff me right up.
We've only got 3 more pages of this, but guys, if you weren't here earlier, Butter, come here. Butter's here. We're gonna show. Oh, He wants his tummy rubbed. I can't rub your tummy right now. Come here. No, come here.
Oh boy.
1 second.
Talk about a hairy chest.
Oh, come here. You come here. Oh, yummy. This is my dog. His name is Butter.
Very good.
Hey,
Is he
Butter.
named after the character on South Park?
Mm-hmm.
Or is he named
Oh,
after
Omar's
the
going
dairy
live in 8
product?
minutes.
Wait, what?
So
you're
Omar's
not
going live in
don't
8
even-
minutes.
You can't even hear me. Okay.
I could kind of hear you, but not really.
I was gonna.
I knew
Is
you were
he-
talking.
Is he named after the South Park character, or just you love dairy products?
No, so here's the thing. I name my dogs after like something that will make people feel stupid if they yell at them and they're mad. So like my last dog's name was Muffin. But this
Uh-huh.
dog's name is Butter. And that backfired hugely because I was driving him home from the vet one day and someone rear-ended me and I was on the on-ramp to the interstate in rush hour traffic. So
Oh,
I had to get out and
no.
talk. I had to get out and talk to the guy.
Yeah.
And Butter escaped the car and he was running around.
Butter?
I feel like I probably told you the story before, but I'm going to tell it anyways. Butter's running around the on-ramp to the interstate, and I'm like, oh my God, what do I do? And all these people are honking because they're in traffic, and I'm not moving, obviously, and I'm just like screaming. I'm like, Butter! Butter! And I'm waving my arms and like trying to get him to pay attention to me, like literally just doing any radical body movement I can to get him to be like, oh my gosh, I should go see what's going on with my mom. So yeah, I just look like a fucking idiot. And by the time I got him back, because he did finally, after I finally fell over because it was raining, after I finally
no.
fell over on the pavement because it was raining, he was like, oh, okay, fine. Okay, fine. So he comes over and I get him. And by that time, I was just kind of like, listen, dude, there's no damage to my car. Let me just go home. So,
Oh no.
and nothing bad happened. I mean, nothing happened to the car.
See, this
So-
could be a viral TikTok if somebody was filming you and it was just sort of like, I just saw somebody get rear-ended and they just got out of their car screaming butter over and
Yeah.
over again. What is happening in the world? That would be a viral TikTok. Maybe.
Yeah.
Maybe not.
Right. Okay, let's see what we got in the rest of this
3 pages. What do we got? One more email
3
or
more
what?
pages. Yep. Let's see. And then there's 2 more documents on the docket that we'll go through, but they're very short. So luckily they're very short. But I'll pull them up really quick just because I closed them out earlier like an idiot.
Oh my goodness.
I know, right? Crazy. Okay, run reports. Go. I'm happy to say nothing else has come up on the docket since since I last looked at it. Thank God.
Oh my
There are
gosh.
like 5 things that came. It is like towards the end of my workday, and I was like, "Yeah, I'm gonna take my break now." By the way, at 4 p.m. or whatever. Like, so yeah, that was not great. Anyways, Exhibit 9 from Megan to it's Mr. Wallace. Okay.
Our boy, Mr. Wallace.
Yeah. Okay. So this part is pretty much the same.
Mm-hmm.
Seeking your response to the claims of retaliation.
Mm-hmm.
Offer any on the record comment. I noticed she didn't. The only response was the one we saw in the beginning, right?
Yes.
Our reporting also found that you're a longtime consultant in the entertainment industry and that your company Street Relations offers services ranging from public relations to more opaque crisis management. Court records show that your clients have included Paramount Pictures and the YouTube personality Aiden Ross. And in a since deleted LinkedIn profile, you describe yourself as a hired gun with a proprietary formula for defining artists and trends. Okay. As the release of the film approached, Mr.
I mean,
Baldoni
he is in
intervened-
Texas, right?
Yes. Yeah.
So that tracks.
So we saw this in the earlier emails. Did we see this part? Ms. Nathan presented proposals to hire contractors to dominate social media through full social account
Yes.
takedowns. Yeah, okay. There are references in emails to social manipulation and proactive fan posting.
Mm-hmm. We saw that.
Okay. A
Crushing
member
it
of the
on
PR
Reddit.
team wrote, "We've started to see shift." Yep. Okay.
Mm-hmm.
When a
TikTok gossip.
Yeah, TikTok gossip personality posted criticisms. We flagged Jed and his team for more serious action on the social side. Again, doesn't really strike me as a red flag. It's like somebody's going to do a smear campaign, but okay. Let's pull up this other document here. Yeah, right.
This is a lot.
Yeah, dude. It is.
so
At least we got
busy
this. Yeah, no, it is.
I don't even have a job. I've been so busy. I had a couple interviews today. It was interesting.
Oh, what are you planning on doing?
I was talking to some tech folks that were interested in
Sweet.
my resume.
All right, cool. Well, I hope it works out if you liked them. If not, then I hope it doesn't work out. So
I'm still a little early in the fake retirement. I'd like to enjoy the rest of my sabbatical, but
yeah, fair enough.
I'm always willing to network.
Yeah.
All right, what do we got?
Okay. So this is just a. It looks like. Hang on. Am I looking at the right thing here? Yes, I am. Dear Judge Lewis, this firm represents consolidated defendant, the New York Times, in the above referenced action. Today, the Times filed its motion to dismiss the first amended complaint of consolidated plaintiffs Wayfarer, Justin Baldoni, etc. We write to seek leave to lodge with the clerk of court a flash drive containing a video that is at issue in courts 1 and 2 of plaintiff's first amended complaint, or counts 1 of 2, sorry. The video is marked as Exhibit 2, so that's the thing we don't have because it's going to be in a flash drive. And then this is actually after. Sorry, 1 second there. I was just fixing this really quick. After we read the Exhibit 2 and then it wasn't there, I went back to double check, and it is just the video of the New York Times summary, basically, of their article. And so there's nothing there that hasn't been seen by the public before. It's available on YouTube, they say, also, and the website of the Times. So it's nothing huge or groundbreaking. It's just they just want to enter that in, and they waited for some reason until today to do all this. But also, as I noted earlier this week, they did move to add another attorney on their behalf just a couple days ago. And this was due today. This is the last day they could submit this. It's been 21 days since they were served with that. So, yeah, and the next document is actually just justifying why they should have leave to add that. So there's nothing too crazy there. But I don't know. So I don't know how this is going to turn out. I can't confidently say, yes, I totally think this will be dismissed or not. But Omar, I'm sure, can tell us. And so why don't we ask him? Let me redirect you guys over to my friend Omar. Give me 1 sec.
Yeah. Is he covering this document?
He's covering a lot of stuff. I sent him a lot of stuff, documents and stuff like that. He's doing a Lively versus Baldoni update, as well as the Gabby Petito stuff. He was supposed to do this last night, actually, but his roadcaster died, I guess. Mm-hmm. So, all right, everybody, I'm sending you. Oh, go ahead.
It'll be interesting. We may have to let him know that which documents we're interested in seeing him cover in the chat.
Oh yeah, I'll be sure to spam him. Mm-hmm. Okay, everybody, I'm sending you over to my friend Omar, the Tilted Lawyer, who can answer any of your legal questions. Like I said, I sent him these documents in email, so he should be able to take a look at them. And everybody, be sure to tell him Lauren sent you and send lots of bacons. His stream hasn't started yet, but it's starting any minute now because it was supposed to start 2 minutes ago. So let me just text and yell at him. Thanks everyone for joining me tonight. Butter thanks you as well, but he's passed out on the floor right now, so I'm not going to pick him up again. But I appreciate it, and I'll have more content coming your way. Yeah, I'll have more content coming your way. So a lot more content coming your way because there's so much that happened even in the time we read this filing. So thank you everybody, and I will see you very shortly. Bye.